Can you hear me well? Yes? Okay, fine. Good afternoon, everybody, and good afternoon, dear colleagues. Good afternoon, dear Anne. We are all here, not for us, not for the jury members. We're here for Anne Heinisch, because Anne will defend their PhD dissertation in law, and if everything goes right, you will walk out of this room in a little bit more than 2 hours with a PhD in law, but before that you will have to pass the second part of the PhD exam. The first part having been an internal PhD defense in which these members of the jury have grilled Anne for around 2 hours, challenged her and them to the extreme, in which and after which we decided that Anne could proceed to the public defense. The theme and the title of the PhD dissertation is luckily already projected on the screen, so that if I do malpronounce it, you still can read it. And it sounds the Evidentiary Practice of the European Court of Human Rights, critical reflections on its historical, institutional and political underpinnings. This PhD dissertation research has been undertaken under the promotorship, the joint promotorship of Professor Marie-Bénédicte Dambour and Professor Alice Donald. You have to invert the plates to be sure that I would not mix you up, but I know you already. Professor Dambour from Ghent University, Professor Alice Donald from Middlesex University, London. And it is customary when we have a PhD which is started to have a guidance committee which consists not only of the supervisors but also to invite a third person, very often a extramuros, non-Ghent University person, to be part of that guidance committee in order to add, I would say, insight, knowledge and guidance for the candidate. And this is Elisabeth Lambert from the Université de Strasbourg in France. 4 years, I think it has taken, something like that. Well, at least according to my data, Anne, you registered your theme on the 1st of April, not a joke, 2021. You submitted your thesis to the faculty on the 4th of April, 2025. So that makes a little bit more than 4 years. The private defense was on the 14th of May, 2025. So you had all summer to prepare for this public defense. What can you expect, dear participants of this public defense? Well, first of all, a presentation by Anne about her research, about their research. That will take 25 to 30 minutes at most, followed by questions from the jury. And we'll move from the external members to the Ghent University members, as is customary in this respect. But maybe most importantly, you as participants are not just observers and passive watchers of this dissertation, of this exam. You also have the possibility to actively intervene, and I will give you the floor after the jury members to ask your questions to Anne. Be aware, this is for free today. Anne will start charging us from tomorrow for all the questions, so take advantage of asking as many questions as you wish. And it's time for me to shut up and to give you the floor. So I wish you all good luck with your PhD exam.
Thank you kindly, Michel, and thank you everyone for being here. Obviously the esteemed members of my jury, but friends and family have traveled from far to be here, and I appreciate that. So most of you know that for the past 5 years, I've been studying the European Court of Human Rights in Strasbourg. This is a court where individuals can bring cases if they believe that a state has violated their rights under the European Convention on Human Rights. These applications can cover a wide range of different issues. Let's say a person might claim that they have been beaten by police, or that their deportation would expose them to a risk of torture. A mother from Chechnya might say that she was discriminated against when she was denied custody of her own child after her husband's death. Or a children's book author might claim that her book shouldn't have been restricted just because it featured a same-sex couple in one of the stories. States, too, can bring cases against other states, but this happens way more rarely. But when it does, these so-called interstate cases often concern very big events like international armed conflict. A series of cases brought by Ukraine against Russia in recent years are one example. Now, the Strasbourg court, seen here from the inside, is the oldest regional human rights court in the world, and it's very well studied. There is a very vibrant community of scholars that keeps a watchful eye on its every move, and actually many of these esteemed ECHR experts are in the room today or online. But there has been a bit of a blind spot, and that blind spot is the court's approach to proof and evidence. Who needs to prove what? By what means can they prove it? What is the standard of proof by which facts must be established? And are there things that don't require proof? These questions all sound very technical, but they're not trivial. They really go to the heart of what the court does. Evidentiary considerations are not just diverse, they can be absolutely decisive. They are crucial to determine if the parties of a dispute meet on a level playing field or if the scales of justice are skewed. And the stakes are quite obvious, I suppose. If judges fail to recognize key facts, or if they accept falsehoods as fact, then their judgments risk being misaligned with reality. And that obviously undermines both the accuracy of the legal analysis and the fairness of the process. And ultimately, it can threaten to the authority and legitimacy of the court itself. So accurate fact determination is a fundamental aspect of the delivery of justice. Now, I said earlier that this is a bit of a blind spot, but that doesn't mean we don't know anything about how evidence is approached in Strasbourg. In fact, the court itself has spelled out a number of guiding principles. I'm not going to bore you with the technical detail. Essentially, you just need to know the three main characteristics of the court's approach to evidence. It's flexible, it's reluctant, and it's pragmatic. First, the court, like other human rights courts, approaches evidence flexibly. Neither the convention nor the rules of court set out very clearly how evidence is to be assessed. All types of evidence are, in principle, admissible. The court follows the free evaluation of all evidence. And the burden of proof is not necessarily fixed on either one party. It can be shifted. It can also be shared. And while the court adopts the standard of proof beyond reasonable doubt, that standard is applied in a somewhat watered-down fashion compared to domestic criminal law. Second, the court is a reluctant fact finder. Put bluntly, Strasbourg court judges feel a bit uneasy when they are forced to ascertain as disputed or unknown facts. And there are good reasons for this. The court is far removed, both geographically and temporally, from the facts of the cases before it. It sees national courts as better placed to establish the facts, so most of the time it will defer to the fact assessment by the domestic courts, unless this is clearly outrageous. Strasbourg rarely hears witnesses or engages in on-the-spot investigations, relying instead on what the parties themselves submit. And many court insiders actually reject the idea that they always need a full picture of the truth to find out if the convention was breached or not. And that leads me to the third feature, pragmatism. Over time, the European Court of Human Rights has developed a set of techniques that allow it to reach decisions even if the facts are not fully clear. It can presume that certain facts are true. It can shift the burden of proof onto the government. Where a state conceals evidence, the court may draw adverse inferences. It can also find procedural violations when a state has failed to investigate alleged abuses. So these are all very pragmatic tools that help the court move forward despite evidentiary gaps. So at the level of principle, all seems fairly fine, right? Strasbourg's flexible and pragmatic approach should be capable of counterbalancing the very clear imbalance of power between applicants and states. But obviously there's a catch. Commentators have rightly pointed out that the court's application of these principles is often not consistent or predictable. And that's really where my research started. I wanted to understand why that is. If the court keeps restating these same principles over and over again, why do we still see inconsistencies, ambiguities, and sometimes results that puzzle us a bit, to be honest? Is this just a product of flexibility, or are there deeper, more structural issues at play here? So that's the central question that drove my research. What explains the Strasbourg Court's approach to evidence? What factors impact or shape it? And to answer this, I combined two approaches. I carried out a doctrinal analysis of a wide cross-section of the court's jurisprudence, but because I knew that jurisprudence alone wouldn't necessarily reveal these subtle factors, I complemented this with qualitative methods, roughly 5-month ethnographically informed study visit at the court's registry, and 53 research interviews with Strasbourg Court judges, registry officials, and litigators. And this mixed method approach really helped because it allowed me, it provided me direct access into how evidentiary practice is shaped not only by doctrine, but also by institutional culture, by practical constraints and external pressures. And that's also what distinguishes my research from previous research, which has been mostly partial and purely doctrinal. I reveal how evidence is conceptualized at the court. I'm able to uncover how power dynamics and institutional practices influence evidentiary reasoning and to assess whether the system as it stands is in need of reform. For today's defense, I want to selectively highlight 3 issues, 3 factors that directly shape the court's approach to evidence. What I'm not going to do is to go into the historic evolution of the evidentiary system. That's interesting because tracing this framework over time shows that it didn't emerge from, a single coherent vision. Instead, the development has been very, incremental, organic, and it changed in response to changing socioeconomic shifts and broader institutional pressures. So the result is a system that has developed in a bit of a piecemeal fashion. And that's important background, but today we're going to focus on 3 more immediate aspects. First, the lack of a coherent evidentiary regime and the absence of a clear sense of direction for the evidentiary practice. Second, how reforms designed to increase efficiency in case processing have tangible but often overlooked evidentiary implications. And third, how the treatment of evidence is not purely technical or mechanical, but very much influenced by external pressures, including political attacks on the legitimacy of the court. Let me take these in turn. So the first point I want to make is that the court's inconsistencies in matters of proof partly stems from the absence of a coherent evidentiary framework and unifying vision of what the evidentiary treatment should be geared towards achieving. What we see in Strasbourg is not a fully formed regime, but a fragmented and more intuitive practice. And that's partly because judges think they don't need much theory because they can rely on their common sense and that will guide them towards the correct outcomes. My research suggests otherwise. Speaking to Strasbourg insiders was actually extremely fascinating in this respect, I must say. It was judges and registry lawyers themselves who consistently described evidence assessment as something intuitive, something guided by logic more so than a strict theoretical framework. One person said, we're not thinking of a theory, and another conceded there's not a lot of theory involved. Maybe there should be more, but it's usually very much linked to the specific controversy. So it seems that the evidentiary concepts are more elusive than the case law would suggest. And you see this in a number of ways. First, you heard earlier that the court applies the standard of proof beyond reasonable doubt. But talking to people actually revealed that judges in practice often look for something a bit lower, like the preponderance of evidence or the balance of probabilities as seen here in this quote. So we see discrepancies between stated principles and actual practice. But we also, second, see principles shifting, sometimes without explanation. And one good example is admissibility thresholds. For many years, applicants only had to provide a beginning of proof, essentially just enough to weed out what one senior interlocutor called wild accusations. But today, they are actually required to submit prima facie evidence. And a similar shift occurred in the admissibility decision in Ukraine against Russia regarding Crimea, where the court noted that allegations of administrative practices would be admissible if there was sufficiently substantiated prima facie evidence. And that, to me, seems like a far cry from the traditional approach, which only required that they not be wholly unsubstantiated. Third, the court doesn't always appreciate the evidentiary consequences of methodological choices. Take Article 3 of the Convention, which prohibits torture and ill treatment. That has a substantive limb and a procedural limb. Under the substantive limb, it prescribes such treatment, and under the procedural limb, it means that states have a duty to investigate allegations and to prosecute and punish those responsible. But the court does not have a consistent practice of either starting its examination with a procedural or with a substantive limb. What the thesis does is argue that it should always proceed from the procedural, because analyzing the adequacy of the domestic investigation helps find out who is to blame for persisting factual uncertainty. And that makes it easier to ensure that presumptions, inferences, and the shifting of the burden of proof work effectively. And finally, perhaps the most glaring symptom of the absence of a coherent framework, instances where the court simply doesn't follow its own principles. In the thesis, I analyzed 2 judgments which span almost 2 decades, both concerning fatal police shootings. In these judgments, there was no controversy over whether or not the person was killed by police. That was undisputed. The dispute was whether the use of lethal force was okay. Article 2 of the Convention, the right to life, does allow for the use of lethal force, but only if it is not more than absolutely necessary. So logically, one would accept that expect that it is for the government to establish that necessity. But in both cases that I analyzed, the burden was effectively placed on the applicant to show that the force used was excessive. And to me, that is an inversion of principle that is both illogical and unfair to applicants. So taken together, these symptoms really point to the fact that Strasbourg lacks a coherent evidentiary regime. And as I said earlier, this conceptual void is partly filled by the notion of common sense. And this is something that was invoked by people of various levels of the hierarchy to describe what they do when they handle evidence. But common sense is a deeply unstable foundation. The trouble with common sense is that it is neither common, as in universally shared among people, nor particularly reliable. Judges naturally approach it through the prism of their own backgrounds, their own national legal background, their professional experiences, even their own personal worldviews. One judge told me, for example, that his growing up in what he called a tougher society meant that he was a bit less inclined to view certain harsh treatment as inhuman and degrading treatment. He simply couldn't get outraged by something that was completely unacceptable to a colleague of his. What results then is not a shared uniform way of dealing with evidence, but a patchwork of individualized approaches. And there is even disagreement over fundamentals, like should the court take judicial notice of notorious facts, or should it seek evidence of its own motion? The somewhat uncomfortable conclusion is this. At Strasbourg, evidence that is often partial is assessed by judges from very diverse backgrounds. Therefore, relying on a supposed shared common sense is a bit risky. Common sense, as Stuart Hill reminded us, is rarely coherent, it's fragmentary, it's shaped by context, and it very much slips into the subjective and idiosyncratic. So that makes it naive to assume that it will always consistently deliver fair outcomes in cases that hinge on distributed facts. What is needed then is not to abandon flexibility, that's not what I'm saying, but to temper it with more deliberate reflection, to give Strasbourg's evidentiary practice conceptual soundness and a clearer sense of normative direction. Now, the thesis then goes on to argue that the court's evidentiary practice is not just shaped by legal doctrine, but also by working methods. Case management processes, reforms of the past decade have had really tangible impacts on the treatment of evidence, often tilting the balance towards applicants or more frequently towards the state. And this is true across the life cycle of an application, which you see here. At the pre-admissibility stage, before a case is even registered, we see rationalization of processes that tend to favor states and also to make certain harms, especially those experienced by vulnerable applicants, less legally intelligible. How so? In the past, registry lawyers would communicate very, very frequently with applicants. They would ask for clarification, they would request missing documents, missing evidence, but today such proactivity is very much institutionally discouraged. Since the introduction in 2014 of Rule 47 of the Rules of Court, basically, as one person said it, you fail to put a date and you're out. So the formal requirements for a valid application have become very rigid. This rigidity causes problems, as commentators have observed. Alpes and Baranowska, for instance, give the example of the court's refusal to register 26 applications concerning the pushback to Lebanon of a group of refugees who wanted to reach Cyprus by boat. These applications were rejected on the ground that there was no official confirmation of the government action. And the authors point out the irony here, that the court seemed to require proof, a paper trail of something that leaves no paper trail. So this illustrates how narrow evidentiary categories coupled with procedural rigidity can erase the lived experiences of border violence. Then at the filtering stage, the picture is a bit more mixed. Filtering means that incoming applications are routed into different procedural tracks to be decided by a single judge, by a 3-judge committee, or by a 7-judge chamber. And here, evidentiary burdens have actually been lightened for applicants in repetitive cases under well-established case law. So once a systemic violation has been established, it will just be for the applicant to show that they were impacted by this general situation. Let's say the court has found that the prison of Ghent has dismal prison conditions and everyone who's there lives in overcrowded situations, and this is inhuman and degrading treatment. Then you as an applicant would only have to show, I was detained at Ghent prison, and just provide some basic information about how many people were there and how were the conditions. That would suffice. But efficiency also carries drawbacks. Smaller formations of the court now decide more and more cases with less and less time per case file. And that makes it easier for meritorious but not ideally evidenced cases to fall through the cracks, to slip through the cracks. A striking example is Zoletic and others against Azerbaijan, concerning 33 Bosnian nationals who alleged that they were trafficked to Azerbaijan and forced to work in very, very harsh conditions. The case nearly ended up being declared inadmissible by a single judge, but it was rescued ultimately thanks to the evidence submitted by the government of Bosnia and Herzegovina. And ultimately, it resulted in a unanimous chamber judgment finding a procedural violation of Article 4, the prohibition of forced labor. Then at the communication stage, the introduction of the so-called IMSI communication procedure has really shifted the evidentiary landscape a bit. Communication means that the respondent state is made aware of the fact that there is a case pending against it. Now, previously, the registry would prepare a detailed summary of the facts, but nowadays, this responsibility has essentially been outsourced to the respondent government, so to the very party that is accused of human rights violations. The government's version of the facts will form the baseline unless the applicant challenges it. And that means, and several interlocutors at the court admitted, that there is an obvious risk that governments might present one-sided accounts. And applicants face pressure to rebut these accounts. Lastly and briefly, let me turn to the stage of deliberation and drafting. Here we see a lot of dependency on the registry. Judges often simply don't see the case file, and they certainly don't have the time to go and look through the original evidence. One judge said this is a court where the judge cannot read the case file. Instead, they have to rely very heavily on what is prepared for them by the registry, and they face quite a lot of pressure to sign off on things quickly. Meanwhile, training on evidence is not systematically provided to incoming judges and registry lawyers, and knowledge is accumulated in a bit of a more informal way, I would say. It's picked up informally through exposure to fact-heavy cases, and that creates sort of silos or pockets of expertise within the registry. I remember meeting an interlocutor in his office, and he had just gotten off the phone with somebody from a different country team who had asked a question about evidence because they rarely come across them. But the more problematic implication is that sometimes registry lawyers describe turning to their private networks to try and make sense of very specialized evidence like forensic reports or medical reports, which seems to be potentially unfair both to staff and to applicants. And beyond that, judicial policy choices have sometimes made evidence seem almost irrelevant. Take the Burmic case, where 12,000 applications were thrown out for policy reasons, or take Turan and others, where the cases of 400 judges and prosecutors who were detained in Turkey were only partially examined. Those were judicial policy decisions, and they were not linked to the strength or weakness of the evidence. So in sum, the pursuit of effectiveness or efficiency in Strasbourg creates far-reaching epistemological limitations. Judges see only a partial reality, partial picture of the evidence. Vulnerable applicants can have their harms rendered legally invisible, and too much depends on the individual agency and informal networks. And these issues are not just technical issues. These are not neutral dynamics. They shape what evidence is highlighted and what evidence is sidelined. Ultimately, it can have an impact on the parties' chances of success. So the court's growing formalism and drive for efficiency may ease its workload, but they also reshape the evidentiary landscape. And finally, at its most extreme, the court's flexible approach means that evidentiary consideration can carry political undertones. As you have seen by now, no doubt, the ways, the mechanics in which evidentiary considerations shape outcomes is quite technical. It's a bit hidden. So it's really difficult to spot instances when evidence is used strategically to push a doctrinal agenda. But these instances exist, and I say that Sanchez is one of those cases. It is an extradition case where the Ghent Chamber introduced a novel evidentiary test to overturn a precedent that had manifestly irked the judges in the UK. This judgment reserved a long-standing tension between Strasbourg and the courts of England and Wales over two lines of jurisprudence. One concerned the permissibility of whole life prison sentences, the Winter line, and the other concerned a series of judgments concerning deportation and extradition, where the court had imposed certain limitations to the removal of persons. In 2014, the Trabelsi case brought these two lines of case law together. The chamber said that the court extended the Winter principles to the extradition case law. In plain terms, that means if a person risks getting a life sentence in a receiving country, then the sending state must be sure at the time of extradition that that state has a system in place that allows to review and release the person. The US system was found lacking such a mechanism, so the chamber ruled against extradition. Now, for the UK courts, that was a step too far. They considered Trabelsi an unexplained and unjustified departure from earlier case law, and they refused to follow it, and the government wanted to see it overturned. Now, what you must know is that the UK government is actually very savvy when it comes to evidence. They have long used evidentiary arguments to advocate for state-friendly outcomes, from the landmark Irish case to Suring and several others. In Sanchez, they finally got their evidentiary win, even though the case was not actually framed around evidence at all. How did that happen? Well, the Ghent Chamber introduced a new two-stage approach to ascertaining whether an extradition is allowed under the convention. First, the applicant must adduce evidence enough to show that there are substantial grounds for believing that they would face a real risk of a life sentence without parole. And only then will the court determine whether a sentence review mechanism exists from the moment of extradition that allows the authorities in the requesting state to consider if the person should be released. Sanchez failed on the first step. The Ghent Chamber did not find it established that the applicant faced a real risk of getting a life sentence. Now, three aspects of this case stand out to me. The first is that the court abandoned its usual practice of assuming that discretionary life sentences still mean that there is a real risk that the sentence be imposed. Secondly, domestically, the district judge had actually accepted that there was a real possibility that the applicant would get a life sentence. Interestingly, then, Strasbourg departed from this assessment, thereby sort of throwing the principle of subsidiarity out the window, which would have usually really annoyed the UK judges and the UK government as well, because it would have usually worked in the applicant's favor. But here it worked to the applicant's detriment. And finally, the court relied on flawed statistics and failed to account for key contextual factors. such as the severity of the offense under US sentencing guidelines, where life imprisonment was actually the only recommended sentence for the offenses that the applicant had been charged with. So this case illustrates what I call political appeasement through the evidentiary backdoor. It shows that the court's evidentiary flexibility does mean that it can be used strategically to secure a favorable outcome, especially when the court is under political pressure. What does all of this leave us with then? Well, let me borrow the words of a litigator that I spoke to early on in the research. He said, the evidentiary question, you don't need to look at it separately because it's very much linked to the general attitude at the court. When it gets more liberal, it gets more liberal with the evidence. When they get more conservative, they tend to suppress evidence. And that very much captures what I found, the essence of what I found. The court's evidentiary practice is not inherently state-friendly or applicant-friendly. Instead, it's variable, less driven by doctrine and more by caseload pressures, political context, and the workings of judges, and very crucially, the registry. Now, at present, those dynamics tend to tilt the balance towards states and against applicants in what I call a conservative evidentiary turn. The consequences are very tangible. Formal requirements and strict procedures can render certain harms legally unintelligible. Judges often see only fragments of the case file and the evidence, and evidentiary flexibility in the absence of a guiding framework can leave the court vulnerable to politicization. Now, the message of this thesis is not that Strasbourg needs to invent a wholly new, entirely new evidentiary system. The court already has the tools. What is missing is a shared evidentiary vision, transparent, principled, and explicitly committed to level the evidentiary playing field between applicants and states. So that means more transparency in how evidence is weighed, better guidance to applicants on what is expected from them, stronger institutional capacity for handling complex evidence, a culture that treats evidence as integral rather than secondary, and above all, a principled framework that resists being bent by efficiency concerns and political pressure. Only with these commitments, I say, can Strasbourg ensure that its judgments are firmly rooted and resting on a solid foundation of fact, and that they reflect reality rather than distort it. Thank you.